Are we live? Are we live on Twitter? We should be live on Twitter. All right, folks. Welcome to Gamcast Live on Twitter. You may be listening to it later on the Rumbles or the YouTubes, the Substacks or the Facebooks, etc. If you are, please hit the like button, subscribe, do all that great stuff. Tonight, we're here to talk about Judge Cannon's decision. I wanted to go live yesterday and talk about it. Unfortunately, it's 93 pages. I read all 93 pages, but it took me 24 hours to do it. I'm here to tell you, she's correct. She will be affirmed. I'll explain later. I'm going to try to keep this under 5 minutes. She might end up having to go to the Supreme Court because, as Andrew Weissman is going to explain in a little bit, I'm going to try to keep this 5 minutes, maybe a little over. We'll see. We're going to walk you down. So here's the basic gist of what happened. The case has been dismissed. No, it's not over for Trump, okay? She can be appealed to the 11th Circuit, and she will be. The 11th Circuit is the circuit that presides over Alabama, Georgia, and Florida. So obviously, she's in Florida. That's the appellate court you go to. They've already reversed her before. It is a quote-unquote conservative court, but in the era of Trump, that doesn't really mean a lot. So we'll see what happens there. Don't know. For those of you who are wondering, they won't be able. They could possibly expedite it and get it done before the election, but it's very unlikely. So now, if she's affirmed, then they would have to. The United States would have to petition the Supreme Court to take it. They might not. I'll get to that in a minute. I will tell you this. One other question I've been getting a lot of. I want to make sure people understand. Yes, it is not dismissed with prejudice. The United States can bring the case again if they can correct the infirmity. But let's get right to the infirmity and what happened. So why did this come about? Well, you'll recall a few weeks ago the Supreme Court issued a decision in the Trump immunity. Now, Thomas filed a concurring opinion. What is a concurring opinion? He signed on to the majority opinion granting Trump immunity, which was the correct decision, by the way, but we want to get into that. Number two, he decided to write separately. Now, why did he write separately? Because he wanted to make another point. No one else, I don't believe anyone else signed on to the concurrence. So it's not the opinion of the court. It only has one justice. But he spends a lot of time, and it's very important, and he points out this issue that had been raised to the court. Now, I think the Supreme Court didn't get to this issue because they didn't need to. They'd already ruled he had immunity, so we don't need to get into this issue of whether or not the special counsel is proper. But he says right here, you can read, this is his opinion. And by the way, if you're listening on the Rumbles or the YouTubes, I will drop it in there so you can read this yourself, a link to it. Unfortunately, I can't do that on Twitter. I hadn't figured that out yet. Maybe there's a possibility you can do it. We'll see. Anyway, none of the statutes cited by the Attorney General appears to create an office for the special counsel, and specifically not with the clarity typical of past statutes used for that purpose. Now, he goes on to basically lay out the framework that Judge Cannon later, and here's Judge Cannon's opinion. Again, I'll put a link to it. You can read it yourself. She had this opinion yesterday. Do you have a timestamp on here? I know it's timestamp. But this is what it looks like when an opinion gets issued in your case. You can see up at the top here, right up there, I highlighted in the blue, you can see all the docket, all the information, case number, etc. Now, skipping ahead to Judge Cannon's opinion, she really gets to it, and this is, I believe, on page 22. I am correct, it's on page 2. The court now proceeds to evaluate the 4 statutes cited by the special counsel as purported authorization for his appointment. 28 U.S.C. section 509, 510, 515, 533. Folks, they all have to do with the Attorney General, and we're going to go over a couple of them again, trying to keep this under 5 minutes so you get the basics. And so I'm not going to go through all of them, but just going to give you a sample. Now, folks, what was Clarence Thomas, by the way? What was Clarence, the Justice Thomas, talking about when he said there's no clear statute? Well, that's crazy. Yeah, well, he's right. The Independent Counsel Act was passed in 1978, and it expired in 1999. You'll recall President Bill Clinton, had been prosecuted under it, and he wasn't too happy about it, right? And so it was part and parcel that they let it expire. Nonetheless, you're sitting there going, wait a minute, that's strange. We had several special counsels appointed under Trump. Mueller was a special counsel. In fact, Weissman, who we're going to get to in a minute, he worked for Mueller. That's strange. Well, what about Hunter Biden? That's really weird. What's going on here? Folks, they're not following the law, basically. And Judge Cannon is the first judge to catch him on it. Now, it's been raised in D.C., and D.C. came to a different conclusion, as Weissman's going to point out in a minute. So, folks, she proceeds to go through all of these and point out, for example, if you go and you read section 515 A and B. He mainly relies on B, but A. It reads right here. The Attorney General or other officer of the Department of Justice and any Attorney General specifically appointed by the Attorney General under law may specifically blah, 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 whether or not he is a resident of the district in which the proceedings is brought. Well, exactly. In other words, you don't have to be a resident of Georgia to be appointed special attorney for the Northern District of Georgia. I can send you up to Massachusetts and you can prosecute a case up there, but you got to be appointed by the Senate and appointed by the President and approved by the Senate. Same thing with B. Each attorney specifically retained under authority of the Department of Justice shall be commissioned as special assistant to the Attorney General and shall take the oath required by law. So what? Doesn't have anything to do with that. She goes on. 28 USC 533, which, by the way, deals with the FBI, and you can see it here right in front of your face, right? The Attorney General may appoint officials to detect and prosecute crimes against the United States, to assist in the protection of the person of the President, to assist in the protection of the person of the Attorney General. You can conduct further investigations, right, in official matters. Where in there does it say that you are endued with the powers of the Assistant Attorney Generals, right, and district attorneys that are, every state has one, whatever district you're sitting in right now, there is one. Nowhere. So basically, Judge Cannon spends the first 40, 50 pages going through all four bases that Merrick Garland listed, all of them, and they're all in 28 USC, different part, I've already gone through that, and says, hey, none of these authorize this person who was not appointed by the President and not approved by the Senate to prosecute crimes. So you can't do it. Now, she spends the remainder of the time going over another issue, which is there's some dicta in Nixon versus United States that talks about the appointment of special counsels, but that's just dicta. That doesn't say you can do it. At the end of the day, folks, what's going on here is, as per usual, Biden's not following the law. They're not following the Constitution. They're just making it up as they go along. And it's an important thing before we get to Weissman here, because I want you to hear the other side. But before we get to the other side, this is not the first time they've done this. You want to know when they had the vaccine mandate? You want to know when they had the mask mandate? And when you go, where's your authority to do that? Oh, it's over here in this act from 1941 where you can quarantine cows. What? Oh, well, where's the authority to forgive student loans? Oh, it's in this 2000 act talking about the president can suspend student loan payments if somebody's sent off to war. You didn't suspend them, you quote-unquote canceled them, and these people aren't at war. This is what fascists do. They just point to something and say, that authorizes me to do it. Plain and simple, you cannot create out of whole cloth an office. That's what Cannon said. Now, folks, here's the other side. I want to get to it, wrap this thing up. Here's Andrew Weissman. He worked for Mueller. He's on MSNBC. Anyway, let him tell you the other side, and I want you to carefully listen to how he dissects the specific arguments that I told you Cannon made in her 93-page opinion, and listen to his view of the world.
Weissman, former FBI general counsel and New York University law professor. Andrew, just what are your thoughts?
Sure. So it's important to focus on exactly what Judge Cannon did here. The judge said that the appointment of a special counsel under the appointment clause of the Constitution, as well as the appropriations clause, which is funding, so both the appointment clause appointing him and the appropriation clause of the Constitution funding him, under both of those constitutional provisions, she said that the executive branch does not have that power. So she's restricting the power of the executive branch of government, that is the president, the attorney general, from appointing a special counsel, saying that that's something that would have to be done by congressional statute, or the president himself would have had to have appointed this person, not Merrick Garland. That's her ruling here. It is in
again, that's not exactly true, but it's close, right? Whether she seems to say, as I read the opinion, even if you had gotten them approved, you can't create this special office. What you could do is what I believe in her opinion. Again, 93 pages. It ain't easy to read. A lot in there. You'd have to give it to somebody, which is what they did for Hunter's case. His one is being prosecuted, again, under special counsel, quote-unquote, regulations that are unconstitutional, but at least he's been appointed by the president, approved by the Senate. He's going to make one other point, and I'm going to wrap this up.
Distinct contrast to all of the other cases that have dealt with this, because I'm sure a lot of...
And what he's saying there, and he's correct, other judges have come to a different conclusion, which is why the Supreme Court is likely going to have to resolve the dispute, because the D.C., They say it's fine. No problem. You don't have any real specific authority. The statute that provided for this expired. No big deal. No problem. So the way this works, folks, is we'll see what the 11th Circuit does. If the 11th Circuit affirms canon, I think they will. You'll have a conflict. Supreme Court likely going to have to resolve it. Anyway, folks, I got to wrap this up. Look for more videos coming, and don't forget to subscribe and spread this video if you enjoyed it.